सर नमस्कार।
नमस्कार नमस्कार।
हाँ सर। So, dear participant, now our resource person, Professor R.K Pandey sir already joined. So we will start the session without delaying. Okay. So, dear participant, we are very happy today. We have Professor R.K Pandey. Professor R.K Pandey is a professor of law in VSSD College, a very old college from the Kanpur University, and sir is expert of the constitutions. You know, the constitution is our most important book, constitutions of India, by which all the country things are governed. All the rules and regulation, what we are living today, even government policy, everything depend on that. So, sir is going to give a brief outlook of the Constitution of India. So, sir, welcome you in our 5th FIP program of the Mizoram University, and we are very happy that you are ready to share your experience, your knowledge about the Constitution of India with our participant. So, with this brief introduction, sir, I am handing over the session to you for your lecture and presentation, sir.
Thank you, Professor Verma. Am I audible?
Yeah, sir, you are audible, sir.
First of all, I am thankful to Professor Verma and his institution for providing me this opportunity to share my thoughts. Now, Professor Verma and my young friends, all of you are faculty members. So it is not a class. It is the exchange or sharing of thought process. So far as the topic is concerned, we have to delve about the Indian Constitution and its salient features. Constitution is the land of law of any country, wherever it may be. But before discussing the Indian Constitution, let us start about the constitutionalism and the modern era of constitutionalism, from where it originates. What is the genesis? To my mind, a great jurist, John Locke, from his philosophy, inspired the era of constitutionalism, and the first effect of his philosophy came before us in the form of American Constitution. And after that, a new era of constitutionalism evolved in the modern world, and subsequently Australian Constitution, Canadian Constitution, and now we have our own Constitution. You may ask, what is the difference between the terms Constitution and constitutionalism? Constitution is the document which deals about the system of the country, how we are going to work, what is the structure of our government, what will be the rights of the citizens. But without a healthy environment, without a culture to follow our constitution, it will be of no effect. And this culture, this healthy environment is known as constitutionalism. So, in spite of being a constitution, the important aspect is we must have constitutionalism. And in this backdrop, we want to start with India. In India, East India Company was ruling, and the first step towards a government was made in 1858, when the transfer of power was made from East India Company to British Parliament. Thereafter, the Government of India Act 1909 1919, and lastly, the Government of India Act 1935, which is the backbone of our Indian Constitution. Indian Constitution was made after the Cabinet Mission Plan, and our Constitution framers in Constituent Assembly deliberated and delved in detail to give us such a nice and largest constitution to we the people of India. Now about the salient features of Indian Constitution. In the modern world, the basic classification of constitutions are written, unwritten, unitary, and federal. Our constitution is a written constitution, and whenever we discuss about unitary and federal, according to me, our constitution is federal constitution. Some constitutional experts raise a question about its being federal, but let us discuss what is the characteristics of federal constitution and what are there in our constitution. In federal constitution, the basic concept is two tiers of governments at central level and at state level or provincial level. And the second most important is the distribution of power by the constitution itself. In our constitution, both elements are there. There is the Union of India and states. The distribution of powers, legislative, financial, as well as administrative, were made by the constitution itself. Some people raise question about the exceptional powers. For example, exceptional legislative powers to the center and emergency provisions in our constitution. First of all, I want to point out that before our constitution, states like Bihar, UP, Assam, Mizoram, Nagaland were not a sovereign state. So we are not a federation in the sense of United States of India, comprising various sovereign states. Our federation is Union of India, having different units. And so it must be kept in mind about discussing our federation. Whenever exceptional powers are given to Parliament, like Article 249, where Parliament is empowered to make legislation on state subjects in national interest, or Article 252, where Parliament enacts on request of two or more states, or when Parliament enacts under Article 253 for implementing of national treaties. All the powers are exercised by Parliament, where representation of states are there in both house, in Lok Sabha as well as in Rajya Sabha, House of People and Council of States. So far as emergency powers are concerned, there are three types of emergency powers under our constitution. Article 352, national emergency, 356, president's rule in states, and 360, financial emergency. In the established pioneer constitutions like US, though there were no emergency powers in the constitution itself, their Supreme Court authorized the state to exercise the powers. But our constitution framers provided for the emergency situations to cope with it. Nation is more important. Other points are not comparable to the security of the country, integrity of the country. So we may say that our constitution is a federal constitution with centralized tendency in situations when it must be handled by the center. Our constitution follows the principles of rule of law, which was propounded by Professor A.V. Dicey. The basic concept in our constitution is equality before law and equal protection of laws. All the persons are equal. Our constitution applies to all of us, even to us like ordinary citizens and our parliamentarians, our Prime Minister, President of India, Chief Justice of India. There is no discrimination, and protection of laws are available to all of us. So we have the rule of law and not the rule of men or women. Our system is of republic. Our head of the state is elected and not hereditary or dictatorial. We have separation of powers. There are three wings in a state: legislature, executive, and judiciary. Though in parliamentary form of government, it is very difficult to separate in a compartmentalized system executive and legislature. However, their works are defined, but the executive is responsible to the legislature and judiciary works independently. Previously, as per the provisions of our constitution, appointment of higher judiciary like High Court and Supreme Court were made by the executive in consultation with the Chief Justice of India. But now, after the Scora case, the situation has been changed, and now the collegium system is there. Collegium recommends the names for appointment to High Court and Supreme Court to the executive, and that was approved by the executive under the seal of the President of India. If we compare with the unitary governments, in unitary system, parliament will not be challenged. For example, England is there. There the parliament is supreme. In our system, there is constitutional supremacy. Our constitution is supreme. Neither legislature, nor executive, nor judiciary is supreme. Constitution is supreme. And so, any laws enacted by the parliament or state legislature may be challenged before High Court or Supreme Court. For higher judiciary, they have two types of functions. First, to decide the disputes brought before them. And second, the interpretation of constitution and other laws. So, High Court and finally our apex court, Supreme Court of India, is the final arbiter of our laws and constitution. So, a law can be declared unconstitutional by High Court or Supreme Court if it is not in accordance with the provisions of our constitution. Previously, there was no restriction on amendment, that is amending power of the parliament. But now, after the Keswanand's case, when basic structure doctrine was evolved by Honorable Supreme Court, Parliament have no power to change the basic structure of the Indian Constitution. However, it is still not clear what are included under the basic structure concept. Though the Supreme Court in many cases gave some example to us, like independence of judiciary, parliamentary form of government, secularism, and all that. But still, the list is not exhaustive. After the Kesavanand Bharati's case, a bench was constituted to discuss and decide what is basic feature, what is basic structure. But later on, the bench was abruptly dissolved and the hanging sword is left there for our legislature. No one knows what is the basic structure in detail. There is no exhaustive list. But that is the present situation. And we, as a student of law, deals with the constitutional provision, legal provision, and not about the politics behind the law. Other salient features of our constitution, if we deal with priority or fundamental rights, directive principles, and fundamental duties. So far as fundamental rights are concerned, reading along with our preamble, our constitution is there to provide justice, social, political, and economic, liberty to all. And these concepts are enshrined in chapter 3, that is fundamental right, in detail. Right to equality, the same concept which we discussed in the rule of law, equality before law, and equal protection of laws. However, equality, the concept of equality is not among unequals. Equality is to be among equals. And therefore, according to Supreme Court cases, we may classify, but the classification must be reasonable. And taking this clue, our constitution is empowered to provide affirmative justice to SC, OBC, women, children, and there is no bar on this in the name of equality. The most important right we have is under Article 21 of our Constitution, right to life and personal liberty. The article says no person should be deprived of his life or personal liberty except according to procedure established by law. This short article is today the most important article of the Indian Constitution after Article 32. Though initially, after making the Constitution, if we see the approach of our judiciary, in 1951, in A.K. Gopalan's case, our Supreme Court held that personal liberty means only physical liberty. And if there is procedure established by law, it is sufficient and it cannot be challenged. And here comes two types of concepts prevalent. One, the procedure established by law, which is British concept, and due process of law, which is American concept. In England, Parliament is supreme. Therefore, whatever procedure is established by law, that cannot be challenged. But when we discuss about the due process of law, American Constitution, that says that it is not required only that there must be a procedure established by law. The law and the procedure must be fair and reasonable. That is the difference between the procedure established by law and due process of law. And what the decision in A.K. Gopalan's was affected by the British mindset, that is procedure established by law, because we were under Britishers, and at the early age of Constitution, the system was affecting our judges. They were the old judges. But slowly, the concept changed. And if we see, there are plethora of cases like Menka Gandhi, Rudal Shah, and many more, where it is held by the Supreme Court of India and many other high courts that if there is any law, if there is any procedure established by law, it must be fair and reasonable. It means that if the law is unfair, unreasonable, it may be declared unconstitutional. And so our Supreme Court, by interpreting Article 21, moved ahead. Though from 1950 to till date, there is no amendment in Article 21, but the meaning has changed 360 degrees. First of all, peace meal orders were issued. In Mohini Jain, it was declared that right to health is a fundamental right under Article 21. And then there is a list of cases, plethora of cases, where one by one rights were declared the fundamental right under Article 21. Right to education, right to health, right to clean environment, right to clean air, right to clean drinking water. And after that, when our apex court tried to make the list longer, it was said that any right which does not come under the purview of any other fundamental rights, it is included there in Article 21, right to life and personal liberty. In 1951, it was right to life and personal liberty. Now, it is right to life with dignity. So there is a sea change. Thereafter, many more fundamental rights in our Constitution. Religious freedom is there. Every person is free to practice his own religion as per his own conscience. There is cultural and educational rights. And hence, though we are in democratic society, democracy means the rule by majority. But our Constitution protects fully the rights of minority. We are in the rule of majority. It doesn't mean that we cannot protect minorities or their rights are not safe. So, in our fundamental rights, all the sections of our society are protected. One point we must note. In Article 21, the word used is person. No person should be deprived of his life or personal liberty, except according to procedure established by law. Means, even if he is not the citizen of India, in Article 19, where the various freedoms are described, there the word is citizen. But under Article 21, the word used is person. So, under Indian Constitution, every person who lives in India, he may be the citizen of India, he or she may not be the citizen of India, but he has the equal right to life and personal liberty. If we discuss the other features of Indian Constitution, there is directive principles of state policy. Directive principles of state policy are the guide, norms, directions for the state to achieve the concept of welfare state. Though the basic difference between the fundamental rights and directive principles of state policy is that fundamental rights are enforced under Article 32 and 226 of the Indian Constitution. But directive principles of state policy are not enforceable. They are the guidelines, they are the ideals, they are the norms inherent in our Constitution for the state to fulfill. And so, there is basic difference in these. So far as Article 32 is concerned, Ambedkar has said that if someone asks me to say about the most important article of the Indian Constitution, that is Article 32, the constitutional remedy. All the fundamental rights are futile if there is no remedy for their enforcement. And that is there under Article 32. However, we may also go to high courts under Article 226 of our Constitution, but Article 226 is not a fundamental right. Article 32 is in itself a fundamental right. And so, Article 32 is most important article, and through the help of this article, we enforce our fundamental rights whenever infringement happens. So, if we compare the active principles of state policy with fundamental rights, the fundamental rights are much more important. But the active principles are not less important in the sense that it serves as a pointer, as ideals for the state to develop further, to achieve further goals towards the welfare state. What is the concept of welfare state? There were two concepts, the concept of laissez-faire or police state and the concept of welfare state. In laissez-faire, the concept is that a state is interested to do only those duties, those functions which cannot be performed by any other. For example, law and order, justice delivery system, lawmaking, external affairs, defense, currency. These are the matters which can't be performed by any individual or private sector. But in contrast to that, in welfare state, everything is entrusted to the state, which is meant for welfare of the people. For describing this, we use that from birth to death, everything has to be dealt by the state. But this statement is also not sufficient. Nowadays, even before the birth, the state is involved. There are many schemes for pregnant ladies and for safe delivery. And the same is applicable after death. In a welfare state, even after death, the state is responsible. If a person has no heir, then the last rights is to be arranged by the state. And hence, there is no limit of the functions performed by the state in a welfare society. And it can be seen through the various legislations which are beneficial to various segments of our people. Minimum Wages Act, Payment of Bonus Act, Maternity Benefit Act, Children Act, and there are many more which are made for various segments to fulfill the basic concepts of welfare state. So, our constitution, through the DPSP and its preamble, delves towards the concept of welfare state. One most important tenet of our constitution is secularism. However, this concept is made controversial due to politics and misconception. First of all, secularism, what it means. The basic concept of secularism is what the state can do or not to do. There are two types of concepts. First, the state has nothing to do with any religious activities. And that is practiced in United States of America. And the second concept is who have to treat every religion equally. In India, we say Sarva Dharma Sadbhav. And mind it, secularism has nothing to do with who goes to temple and who goes to mosque and who goes to church and gurudwara. This is the basic religious faith has been more politicized for the vote bank politics. What the ancient concept of religion was, especially in India, that is dharma. And the dharma was defined as dharmo viswasya jagata pratishtha. Dharma does not mean process to worship. It includes all the knowledge, history, politics, law, sociology, psychology, arts, music, all were included in the concept dharma. And so it was a broader concept. Now it is discussed in a narrow sense. And so politicians confuse the society and bargain the votes. As far as separation of powers is concerned, though in parliamentary democracy, it can't be separated in independent compartments. There are separation. Legislature is to make laws. Executive has a duty to implement it. And our judiciary, especially higher judiciary, is to decide disputes and interpret the constitution and laws. The judiciary has power of judicial review, whereby any action of executive as well legislature can be reviewed by the judiciary, especially higher judiciary. Independence of judiciary and one more concept evolved, that is judicial activism. And it culminated in the concept of PIL or SAL, public interest litigation or social action litigation. The pioneer was Justice P.N. Bhagwati. Previously, the court was only bothered about the dispute brought before it, and the right, that is locus standi, was only to the person aggrieved. But this concept of PIL changed this concept drastically. Now any other person or organizations for the public interest approach the court under Article 32 and 226 for seizing the matter. And there are many important cases under this segment where Supreme Court and High Courts provided detailed guidelines for reform in prisons. What are the rights of prisoners? What is the right of a person who is arrested? The important cases are D.K. Basu's case, Hussain Ara Khatun's case, Nandini Satpathi's case. So the concept changed, and now it is not only the victim who can approach the court, but even his friend or relative or any social organization may approach the court if the court thinks that it is of public importance or the point raised affects the public at large. The court decides and issues guidelines. Though this was welcomed by the people in general, but criticized also by a quarter, that judiciary transgresses its limit and it must limit itself to its assigned work and must not try to interfere in the field of executive and legislature. We have discussed about the basic structure doctrine. There also this criticism was there. Supreme Court held that secularism, independence of judiciary, all these are basic structure. But with all the due regards to Honorable Court, the power to appoint judges in higher judiciary was initially with the executive, with the consultation of the Chief Justice. But now, after the Scora case, the collegium system evolved, and the present position is that whatever collegium recommends, it is binding on the executive. So whether such an important aspect was not the basic structure, but it is to be left for future. Once the National Judicial Commission amendment was declared unconstitutional by the Supreme Court, we have to see what happens in future. About the amending process of Indian Constitution or amending power of the Indian Constitution, it is said that in federal constitutions, amending process must be rigid so that powers of states are not curtailed at the whims of the center. But our constitution have the balance for the provisions which affect the states. The constitution provides that after the 2/3 majority of the parliament, minimum half of the state legislatures must ratify, and then only the process completes for presenting it to the President of India. But where the provisions are not that important, affecting the states, their process is simple so that it may not be the obstacle for our development. And so 105 amendments have been made so far in our constitution. So if we see these provisions, our constitution is a balanced constitution. Secular state, republic, having fundamental rights, directive principles, and the one major aspect related with the FR and DPSP, or fundamental duties, though it was not there earlier. Now it has been added, and we, the people of India, has been interested to perform fundamental duties, so that we must fulfill our responsibilities towards the Constitution. One thing to be clear about the federal concept, we must discuss in detail the distribution of legislative powers between union and states, because this is the basic bone of contention between union and states. Article 245 of Indian Constitution provides that the Parliament has a territorial jurisdiction over the whole country for making laws, and state legislature has a territorial jurisdiction to its state limit. So, Article 245 is there for territorial distribution. Article 246 deals with the legislative powers regarding subject matter. Under Article 246, there is the provision of 3 lists under 7th schedule of the Indian Constitution. First list, that is union list. Second list, that is state list. And third list, that is concurrent list. Parliament is empowered to make laws for the subjects in union list. And so, it is assumed that those subjects which are in union list are matters of national or international importance. Second list or state list, the subjects are there of local importance, or for legislation of them, state legislature is empowered. For concurrent list, whatever the subjects are in that list, Parliament and state legislature both are empowered. That means there are the subjects which are of local importance, but they may assume sometimes as of national importance. So, both the legislatures are empowered to make the law. But if there is contradiction between these, the parliamentary law will prevail. In relation to that state where the contradiction exists. But if a state has passed a law on the subject of a concurrent list, and such a law has been reserved for the assent of President of India and consented by him, approved by him, then such law will prevail over the parliamentary law in that state. However, the ultimate power rests with the parliament. Even after that, parliament may provide for the implementation of parliamentary law, but these provisions are only for the extent of contradiction. If there is no contradiction, both laws will be applicable under the concurrent list. There may be a subject which has not come to the mind of our constitution framers, or till time not incorporated in all the 3 lists, that is union list, state list, and concurrent list. For these subjects, the Constitution provided under Article 248 a head of residuary power, and under Article 248 power to legislate on a residuary subject vests with the Parliament of India. That means any subject which is not there in union list, state list, and concurrent lists, such subject, if needs legislation, that legislation can only be enacted by the Parliament of India and not by the state legislatures. Article 249 of Indian Constitution provides that if there is any subject in a state list and it becomes the subject of national importance, and the Council of States, that is Rajya Sabha, passes a resolution to this effect that such a subject has been now of national importance, national interest, and Parliament should enact on this subject. Then only under Article 249, Parliament is empowered to make law on that subject. Till the resolution of the Council of States exists, and after the resolution ceases to have effect, the legislation will not have effect. Under Article 252, there is a provision that if two or more states, after passing a resolution in their legislature, empowers the Parliament to make law on that subject. This article is used in situations when the subjects are not limited to state boundary. Earlier, there was problem of dacoit infested areas in Madhya Pradesh, Uttar Pradesh. Now there has been many problems of Naxal affected states. These problems are not limited to the boundary of a single state. So if the state legislatures feel that there are the separate laws of a state and they are not effective in combating the problem, then there is a need of parliamentary enactment, and so they request the Parliament by their resolution authorizing the Parliament to make law for such states. And any such law passed by the Parliament under the resolution passed under Article 252, these laws will be applicable only in those states. However, after passing the parliamentary enactment, any other state by the resolution may accept such law for their state. So, this is the power which is being authorized by the states itself to the Parliament, and so Article 249 or 252, if anyone says that these constitutional provisions are an encroachment or interference in the state sphere, then it is not true. Because in Article 249, the resolution is made by the Council of States, which is the representative of states. And in case of Article 252, a resolution is made by the state legislatures, those state itself who want the law to be enacted by the Parliament. Under Article 250, there is a provision that whenever national emergency is declared under Article 352, then the power to legislate on state subjects for that state or those states which were covered by national emergency, then Parliament is empowered to legislate on state subjects for that state or those states. But Parliament has to declare while enacting such law that this law is being made under the authority of Article 250. And any law made under the authority of Article 250 will cease to have its effect whenever, after the emergency ceases and 6 months expire. Means after the end of emergency, maximum 6 months is allowed for operating of such laws. However, Parliament may repeal the law even before the period of expiry of 6 months. It means that Article 250 or 249 or 252 empowers only the Parliament for a specific purpose, for a specific subject, and for a specific period. And even national emergency or President's rule under Article 356 or financial emergency under Article 360. Any one of these provisions of emergency powers provided in our Constitution may be continued only after the approval of the Parliament. So if the Parliament disapproves, it is not of any use. So either the states are authorizing, requesting, or the Parliament in a state of emergency empowered to make laws for states for a specific period, for specific subjects. In this chapter, there is one more article, Article 253, which provides for implementation of national treaties and protocols. Though the external affairs is under the Union, that is, the Parliament is empowered to make any law related to the matters of external affairs, and the subjects related to external affairs are there in the Union list. But if there is any international treaty, agreement, or protocol which is binding on India, or which has been ratified by India, and for the implementation of that treaty, that agreement, that protocol, change in municipal laws is required. And if the subject related is under the state list, then under Article 253, Parliament is empowered to make that law for implementation of the international treaty, agreement, or protocol, so that external affairs matters will run smoothly and there may not be any obstacle in our international relations. Under Article 254, which deals with repugnancy, we have discussed that Parliament and state legislature both have the power to legislate on the subject matters provided in concurrent list. But if there is any contradiction, to the extent of contradiction, the law made by the parliament will prevail in that state. But as Article 254 provides, if there is prior approval or consent of the President of India to that state law, then such state law will prevail over the parliamentary enactment on that subject in that state, but only till the time when parliament, after amending or enacting new provisions, provides for that this law will be applicable in that state also. Means for subject matters under concurrent list, the final authority rests with the parliament. So these are the concepts or system which our constitution have for distribution of legislative powers. In unitary constitutions, the distribution of legislative power is made by the central government. They provide powers to the units or provinces or states as a concept of decentralization. But in the federal constitution, the provision for distribution of power is provided in constitution itself. And so here in our constitution, it is provided in the constitution, and hence our setup is a federal setup. So after discussing the distribution of legislative powers, we may arrive at the conclusion that our constitution is in true sense a federal constitution, and there is no point in making the criticism that this is not a true federal constitution. Like some constitutional experts say, it is not federal, it is quasi-federal. But we may say that it is a federal constitution with centralized tendencies. When we discuss about emergency powers, before 44th Amendment, government was empowered to suspend all the fundamental rights when emergency is declared. Now, after 44th Amendment, it has been made clear that our right to life and personal liberty, which is precious, cannot be suspended in any situation. And we have discussed that it is for a person. So any person who is in India have the right to life and personal liberty, even in emergency situations. If we discuss some unique features of our Indian Constitution, the foremost is single citizenship. In American system, the citizenship is of two levels. One of United States of America and one of the state. But in India, there is single citizenship. Not even that. We have single judicial system. We have single executive system. In US, there is the US Supreme Court, and in every state there is the state Supreme Court. For federal laws, there are federal courts. For state laws, there are state courts. But in India, whether the law is parliamentary or the law is enacted by the state legislature, for both laws, either for interpretation or for deciding the disputes, whatever it may be, the system is uniform. Though under Article 247 of the Indian Constitution, Parliament is empowered to make special courts for parliamentary enactments, but that is a power given by the Constitution. The practice is that there is uniformity of courts, and whatever schemes the government of India has, they have to be implemented through the state machinery. The executive machinery is under the state government, and the responsibility for the district is on DM, and there is no distinct DM for state government or central government. There is no distinct district judge for state government and central government. So we have the uniformity in the system from top to the bottom. There is no distinguished or separate system, because that situation confuses the people and their grievances are not being redressed properly. Here, there is no confusion. Everyone is clear. We have a single system, and we have to approach that system whether we have the problem with the parliamentary enactment or with the enactment of a state legislature. So we have a single citizenship, we have a single system of judiciary, and in emergency, in spite of being territorial jurisdiction, we may approach to any court, especially higher courts, so that remedy may be provided to us. As far as education is concerned, Article 21A has been inserted in our Constitution, and it provides right to education, rather right to free education for children up to 14 years. And for that, in accordance with the provisions of Article 21A, Right to Education Act has been enacted. Though the implementation, especially regarding the admission and education of children in private schools, is not being implemented very effectively, but the process is going on, and we may hope that situation will improve in future. One important aspect of the justice delivery system is that in many instances, we see that in our society, there are many persons who are not capable to afford to approach our legal system. Our great jurist, Professor Upendra Bakshi, that our is a problem. Poor people, illiterate people who are not capable to approach our judicial system. The reasons are cost and time. And so it is popular that justice delayed is justice denied. But for that, our constitution provides for free legal aid. So previously, it was the mandate under the active principles of state policy. But now, our apex court has interpreted under Article 21 the free legal aid. And there is a system, there is a structure from top to bottom to provide free legal aid. For this, and legislation was made in 1987, Legal Services Authority Act 1987. And this act provides for a three-tier system. At the top, NALSA, National Legal Services Authority, and it is being headed by a senior justice of Supreme Court to be designated by the Chief Justice of India. At the state level, the body is SALSA, State Legal Services Authority, which acts under the Senior Justice of High Court to be designated by the Chief Justice of that High Court. And at district level, in every district of India, there is a district legal services authority. District judge is the ex officio chairperson of this authority, and one judicial officer is designated as the secretary of the district legal services authority. This act provides for the free legal aid. The grassroots work is being done by District Legal Services Authority in collaboration with Social Welfare Department of the state, Women Welfare Department of the state, NGOs, and various legal aid clinics established in the law colleges. Previously, due to lack of infrastructure and manpower, there was not much work in the field. But now, the paralegal volunteers are being appointed at the district level, and they are being interested to work in the various legal aid clinics as well as various talukas and tahsils for the legal awareness. The District Legal Services Authority organizes legal awareness camps where legal aid provisions are being imparted to people Legal Services Authority provides for free legal aid. One thing is legal awareness, but if there is a problem and any person who has no resources to hire a lawyer and approach the court, District Legal Services Authority on an application provides the services of a lawyer to such person free of cost. They have no need to pay the lawyer. That is being taken care of the District Legal Services Authority. And anyone who is not in a position, has not enough income, can contact the District Legal Services Authority. If advice is needed, they may contact the legal aid clinics, the paralegal volunteers, or even the NGOs who are working in collaboration with the District Legal Services Authority. So, this is the most important aspect in the modern world where one is provided free legal aid. Because if no legal aid is provided, then it is the infringement of equality. One has the lawyer and the other is clueless about how to approach the court. And I request to the law students and even every person of the society that he or she must be aware himself or herself of the rights of the laws, and if he finds an opportunity, must aware others in the society so that our duty is fulfilled towards the society. If anyone wants to ask something or share something, you are free for that. No?
Sir,
Yeah.
yeah. So I think, sir, you finish.
No, if there is no question, I may continue.
Yeah. Sir, till now, no question, sir. Till now, you can continue, sir.
Okay. Now I must discuss one more important point. The basic concept of justice as per our constitution in traditional way is to decide the dispute. For civil cases, if there is any dispute about the title suit or possession, the court may decide who is the true owner or who must have the possession. But in criminal cases, if we see our system, one party is invariably the state. Because in our laws, in our society, in our concept, it is presumed that if anyone has committed a crime, then the crime is not only against a person or his family, but it is against the society. And state, the representative of society, is being made a party to the case. And in a criminal case, if a person is being proved guilty, then punishment is to be awarded. And this is the justice according to our traditional norms. And victim has no other remedy. But lately, our high courts and Supreme Court evolved a new concept, that is compensatory justice in criminal cases. And for this, we may quote some important cases like case of Ruddal Shah, Fagu Shah, and there are much more cases. These cases were the beginning. In these cases, our Supreme Court says that though the basic concept of criminal law is to award punishment to the accused who is proved guilty. In this situation, the victim gets justice, but that justice is only emotional justice. In modern materialistic world, after going through such an amount of pain, sorrow, and many more problems faced by the victim or the family, social ostracization in sexual offenses, lack of future prospects, all these are for victim and their family. And what he or she gets, if the prosecution is being successful in proving the accused guilty through the court, then the accused is being awarded punishment. So, our higher judiciary from these cases evolved the concept of compensatory justice to the victim, or as the case may be, to his or her family. In addition to the punishment, exemplary fines are being awarded on the accused who has been proved guilty, and from that fine, a portion is being provided to the victim or his or her family as per directed by the court. So this is the new dimension. The family is suffering. Even if where the accused or offender is not in a position to deposit the fine, he is being awarded additional punishment. But in that case, in many cases, our apex court has directed the union or the state government, whichever the case may be, to provide a lump sum as per directed by the court to the victim, or whatever the case, to his or her family. So this is a new dimension due to the constitutional interpretation, due to the interpretation of Article 21, whereby our higher judiciary provided a new type of relief to the persons or their family who undergo a severe pain and sorrow due to heinous crimes. So, this is a new dimension in our criminal jurisprudence. One more thing related to the criminal justice, that is economic offenses. In general, the criminal jurisprudence of our constitutional system says that a person has to be proved guilty beyond any reasonable doubt. That is the criminal jurisprudence of our system. And if there is any doubt, such person has not to be punished. But our many new legislations related to economic offenses provides that the burden of proof of being innocent is shifted to the accused from the prosecution in such cases of economic offenses. So these are the deviations, rather we may say improvements from the traditional criminal jurisprudence, traditional concept of personal liberty, and this is a welcome sign from our higher judiciary. So we may conclude that our constitution is a novel document, largest written constitution in the present world, and it has the ample scope that whenever there is a need, it may be amended by the process enshrined in the constitution itself. And so any saying that the fault lies in the constitution is not true, but according to me, the fault lies, if any, is in we the people of India. Constitution is a document. The people has to implement it. It has been provided by the people to the people, and they have to observe it, they have to implement it through their institutions, organizations. And any person who is at the helms of affairs are from our society, and so we can't recuse us from our responsibility. Thank you.
Manoj, unmute. Manoj, unmute. Manoj, you are mute. Professor Manoj, you are unmute.
Yeah. Sir, thank you so much, sir, for giving a very informative and basic lecture on the Constitution of India, Indian constitutions, which is very informative and enlightenment for our participant. And on behalf of the HRDC Mizoram University, I pay my sincere thanks to you for your valuable time and your expert lecture for this. So my office will contact you after 1 week, 10 days. They will contact once this program will over. They will ask you some your personal bank detail and all to send your certificate as well as your honorarium for this lecture, sir. So thank you so much, sir, for your
Thank you
lecture.
all.
Yeah, thank you, sir. Now you may leave, sir. So, Badandu sir, in this way, we finish our today's session. Dear participant, today again, the after lunch 2 classes is reserved for your book review. I hope last week 2 classes and today 2 classes, 4 classes, you are able to finish your book review things and you are ready to submit on the time. Okay, there will be a very little time in the end. Don't ask us any extension any time. Okay, your course is a time bound course, so every date is fixed, so you do your work. And tomorrow is Sunday, maybe you will get, because we put in our Zoom link from